During this hour, we're taking a closer look at Thursday's hearing for convicted killer Scott Peterson. Now, before we get into that important hearing, here's Court TV anchor Ted Rowlands on Peterson's new efforts to get a new trial.
November 12, 2004, the crowd outside the San Mateo County Courthouse in Redwood City, California, celebrated Scott Peterson's guilty verdicts.
He sat there emotionless as this jury told Scott Peterson, "You are guilty of killing your wife and your unborn son, Connor."
Laci Peterson was 8 months pregnant when she went missing on Christmas Eve in 2002. Her husband, Scott, claimed he had gone fishing alone on the San Francisco Bay the day that Laci disappeared. He was arrested after her body and the body of their unborn son, Connor, washed ashore 4 months later.
Mr. Peterson, you're pleading not guilty to 2 charges of murder plus the denying the special allegations.
Absolutely. That's correct, Your Honor. I'm innocent.
For more than 20 years, Scott Peterson has denied that he had anything to do with Laci and Connor's deaths. And now, the LA Innocence Project has taken on his case, saying that new evidence supports Peterson's claims of innocence.
The court had requested counsel to be present this morning for a status conference.
Court documents filed by the Innocence Project attempt to point to new questions about who abducted and killed Laci and Connor.
We spent a lot of time trying to suss out what, frankly, are very alarming deficiencies in the discovery that was provided to the defense at the time of trial.
The LA Innocence Project now wants post-conviction discovery related to the Modesto Police Department's investigation into a burglary in Scott and Laci Peterson's neighborhood around the time of her disappearance, as well as their efforts to clear the 2 suspects arrested from any involvement in Laci's case.
Mr. Peterson has been waiting 20 years to find some of these police reports and audio recordings and video recordings that should have been provided.
They're also asking for DNA testing on an allegedly bloody mattress found in a burned-out van about a mile from Peterson's home the day after Laci vanished. The Stanislaus County DA's office is standing behind the arrest and the conviction of Scott Peterson and say that police ran down all of the possible leads in this case more than 20 years ago.
Ted Rowlands reporting there for us. And now we want to let you see the very best moments from Thursday's hearing for Scott Peterson. He was there in the courtroom as the focus centered around the handling of DNA testing and the chain of custody with the case evidence. Let's watch.
Today we have a disc to show the court that we have provided all of those items, and it is listed in categories. Due to the nature of sensitive materials on that disc, we don't wish to admit it into evidence and accidentally undo a prior sealing order, Your Honor. But we have either the disc ready for the court to, we can lodge it for the court to review, or if the court would prefer, we also have a binder full of all of the printed materials, including confirmation that the defense has received all of these materials. So with that, we do not know what is deficient. I understand that they are pointing out 1-5A as the adhesive, which we know based off of the records that are all attached in there. That was the little piece of adhesive that Pinkito, the criminalist, did, where she took a little sample to confirm the thread count on the back of the duct tape. When she confirmed that duct tape to all of the other numerous pieces of duct tape that were found within this case. And that slide was also, sent back to MPD, which they have the chain of custody records for. So outside of that, we don't know what's deficient. Our request in our supplemental status conference statement is that, Your Honor, I know that the defense has only requested DNA testing on item 1-5.
Well, they requested far more than that. That was what they granted.
Right. But as pertaining to 1-5, they only requested 1-5. Right. If the court is going to proceed with that order, people are just really asking that you also include the corresponding slides that were specifically done for DNA samples. so that we're not here relitigating the matter again and again because of a future request to solve it.
Okay, then I'll check in with Ms. Mitchell about her preferences on that request for the people. The things that there was an allegation that essentially there is no present log verifying from the Dexter Police Department that the items for which the chain of custody is dated, essentially delivery in, I think, 2005 and a couple of other dates, that those items remain or what the storage conditions of those items were. So can you discuss whether or not the materials that you provided actually have anything related to storage conditions? And if they don't, is that because those materials do not exist? Or what's, how is that dealt with?
I can, up in 2003 through 2005 and onward, this was all handled via paper, both with the Department of Justice Bureau of Forensic Science as well as at MPD. So the chain of custody, and you're referring to defense's claim that the 1-5A doesn't have a subsequent chain of custody log. It's because that chain of custody ended once the Bureau of Forensic Science released that item back to MPD. There was no further checking out, so there's no reason for MPD to then assign it a new MPD case number and create a chain of custody log because it's never checked out. It's currently located at MPD. There is no, because it's a paper format, there is no specific location of where this item is stored specifically on a shelf or in a freezer or anything like that. We reached out to MPD yesterday to confirm, and they show that this has been returned exactly that in August. And again, I'm referring just to that 1-5A, as the Francis pointed out, was returned in August of 2005. It was accepted by MPD, taken in, and at that time, MPD would often, BFS would often put little slides and envelopes, and then they'd write on the outside of the envelope whatever that item is. They would seal it subsequently into bigger envelopes, which would get sealed, and then it would get placed in storage. So there is thousands of items to cycle through. And if the court is wanting our evidence technicians to do that at MPD, we can do so. If the court is going to order testing on the adhesive slide, as for everything else, we have confirmed the location in the box, and that was provided in the discovery to defense that contains the actual 1-5 duct tape that was found on Lacey's remains, as well as any cuttings from that duct tape are in that box. And the 3 subsequent slides, the nations, are in the refrigerator at MPD.
All right, so we're going to hear more from the defense, and we're going to hear more about the duct tape. And ultimately, both sides are going at each other in this hearing to determine what lab is going to test that duct tape, the duct tape found on Laci Peterson's pants. And the defense says this is critical to Scott Peterson potentially getting a new trial. If there's somebody else's DNA on it, then that could point to another suspect. Could that cause this case to go back for a retrial? Let's talk about this. I want to welcome in now. I have with me in Florida, I believe, criminal defense attorney Bradford Cohen, and in New York, retired lieutenant and the commanding officer of the Nassau County Police K-9 Unit and the owner of Houndstown USA, Mike Gould. Great to have you both on the program. All right, so the likelihood that what's on this duct tape could result in a new trial for Scott Peterson. Bradford, would you start us off? Your thoughts, please.
I think it's interesting. It's a small piece of evidence that may have big implications. Is my take on it. Back when these were originally tested, we had very limited areas of testing for DNA, and those testing, the way that we do these testings, has increased, hundreds of folds. And now there's different computers that can actually disseminate, 5 or 6 different DNAs, or if there's a smaller amount of DNA, it can also determine that DNA, as opposed to 20 years ago, where there needed to be a specific amount, and that amount was a lot larger than we need now. So obviously, if it comes back with someone else's DNA on that tape, it raises the question that that is evidence that wasn't available during the trial that originally was held, that is now available. And I think it would give rise to a very good cause of action for a new trial.
Bradford Cohen, appreciate it. Lieutenant Gould, I want to get some insight from you on this. Your thoughts on what could eventually happen here?
Yeah, good morning, Julie. So this Scott Peterson case, I thought it was one and done. The most disturbing part about it is every time I see his mugshot, I realize how old I am. So I thought that there was circumstantial evidence well beyond a reasonable doubt. I agree with Bradford that DNA science has advanced greatly, but DNA is all over the place. So unless there's a clear nexus, just because I'm certain there will be somebody else's DNA on that, if they could, number one, find out who that is, and what other evidence is there. So I see this personally as a nothing burger, unless there is a surprising connection. The DNA reveals something very powerful. But for me, it's grasping at straws. DNA is not always a smoking gun. We always think of a fingerprint or DNA as this, as I said, smoking gun. But there has to be a nexus to other evidence. So I don't think this is going anywhere. He dodged the bullet on the death penalty. I think he's a murderer personally, as the jury did, and that's my thoughts on that.
Yeah, appreciate it, Lieutenant, and great points, because looking at it in a vacuum, this might look promising, but then let's not forget about all the other damaging evidence against this guy. We're going to do much more analyzing and assessing everything in just a couple of minutes. We're going to hit a break. When we come back, we'll show you more of Scott Peterson's hearing, and we'll hear what the defense has to say about the chain of custody. That's an issue. That's coming up next for you here on Court TV Live. Don't go away.
On the next episode of Accomplice to Murder, NBA star and hometown hero Lorenzen Wright. It would take over a decade to uncover the truth behind his disappearance.
If you're Sharon Wright, you decide to kill your husband, who are you going to get to help you?
Who is Billy Ray Turner?
In many ways, he was manipulated.
She planned, she plotted. She's the reason why he's gone.
Accomplice to Murder with Vinnie Politan. All new episode, Sunday night, 8, 7 Central.
Only on Court TV.
Welcome back to Court TV Live. I'm Julie Grant. And during this hour, we're bringing you the very best moments from Thursday's hearing for convicted killer Scott Peterson. With the help of the Los Angeles Innocence Project. That is not the nationally known Innocence Project. That is a small local group not affiliated with Barry Scheck's group. Peterson and his defense team are now pushing forward, trying to get him a new trial. Now, in this next portion you're about to see, the defense presents its issues with the handling of some DNA testing and calls into question the chain of custody of the case evidence. Let's take a look.
The chain of custody are an abomination. I've never seen such poorly documented evidence. Collection, retention, transfers. This is far, far short of what we need in terms of a documented chain of custody. We still don't have an answer to whether the 3 spots exist. We still don't have an answer to whether there are 3 slides or 1 slide. As we indicated in our statement, the handwritten note, which the DOJ, the lab that they want to use, contends is a chain of custody record, is very legible, and it says there's 1 slide, not 3 slides. We didn't really realize that there was this derivative evidence out there that could potentially be very material, and it could be exculpatory, until we saw what they're contending are chain of custody records. We know, for example, if this is what they're saying is the MPD chain of custody for, it says white box. It doesn't say what's in the white box. We also know it has a scan barcode. What normally happens when you have a chain of we have property and evidence logs, you get a printout of every single item of evidence that was collected, where it was taken, when it was entered into property and evidence, when it was checked out, by whom, where it went when it was checked out, whether it was to the lab or somewhere else, when it was received by the lab, what was done to it was while it was at the lab and when it was returned to police custody. We need chain of custody, we need current property and evidence logs from the scanned barcodes for all of the evidence in this case. There was evidence that Mr. Peterson provided, blood sample, saliva sample.
Hang on. Number 1, court report.
Sorry.
Number 2, in the context of the 1405 motion. Now, the 1054.9 motion that we're going to be doing on Monday.
Yes, correct.
The court's order was limited to the chain of custody and the items and the logs for the items that the court had ordered be tested.
So I'm merely suggesting that this is one reason why a complete chain of custody is needed.
Which is going to be taken up under the 1054.9 motion that you've got.
But I'm talking about specifically for the duct tape and for any derivative evidence, including the slides, including the swabs, including the adhesive, which this is a capital case that prosecution wanted to execute my claim. But these records are, as I said, an abomination. This is not a complete record of the chain of custody for this item of evidence that we are seeking to have tested. We would like to have complete, current, barcode scanned MPD, property and evidence, chain of custody for all of the evidence related to item 9 or item 1-5. We would like to have that before any testing commences. We would also like clarification from the prosecution, which we still don't have, as to whether there are 3 slides or 1 slide, whether the 3 swabs still exist and can be tested or retested. And am I forgetting anything? That's what we would like. I think that we need a little bit more inquiry into the status of this evidence. 3 slides in a box. This what they have provided to us, it says that there's a white box. I just don't think that this is, I think we need more information. I think if the court is going to order this tape and any derivative evidence from the tape to be tested, we need to know what the chain of custody is, what it has been, where are these items now. They still haven't indicated where these items are at the Modesto Police Department.
I respectfully disagree because I think I just heard the prosecutor tell me at least some of the items are in freezer. But anything else you want to say, Ms. Mitchell?
I'm deeply concerned about the way this evidence was handled. If this is any indication of what's happening with the rest of the evidence, we're going to have a lot more litigation in the
All right, let's talk some more about this. I want to bring back in criminal defense attorney Bradford Cohen and retired Lieutenant Mike Gould. All right, let's kind of dig into this piece of duct tape. So it's found on Laci's pants when her body washed ashore. This is along the San Francisco Bay back in April of 2003. So apparently it's about 15.5 inches in length, and it's something that was never been tested. Wondering if the water and the conditions could jeopardize what may be found on this. Let's talk a little bit about what it can reveal and can this really change things? Lieutenant Gould, your thoughts on whether the defense is going to get what they think they're going to get from this?
Yeah, Julie, so I'm not a DNA expert by any stretch of the imagination, but where I'm sitting right now, where you're sitting, there is DNA all over the place, hundreds of samples of DNA. But again, as I said earlier, there has to be a nexus, whether water deteriorates it or not. I really don't know. But, I've worked on capital murder cases and I understand the seriousness of it. And when science exonerates an innocent person, that is a miracle. It should be honored. This isn't the case for that, I don't think. I just don't think that with all the other circumstantial evidence. I think he's gotten a great opportunity that the Innocent Project is even involved in this case. There's many, 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 many other incarcerated people that doesn't get that chance with far less circumstantial evidence as this case has. So I just don't think this is the right case. The DNA, let's see what it reveals. I don't see it. The chain of custody is always something important, But 20 years ago, everything was completely different. They didn't have these databases, electronic databases. So again, that's not an excuse, but let's see where it goes. I don't buy it in this case.
Right, yeah, I don't either, Lieutenant. I mean, and Scott Peterson, to me, is a very lucky guy getting his death sentence overturned. And he's also a very determined guy, in my opinion. Remember, he made a bid for a new trial in 2022 when he was moved off of death row, and it was juror misconduct at that point. Juror misconduct, that's what should cause it. Now, I guess he's moving on. Bradford Cohen, do you think, are they grasping at straws here, or do you think there's some viability in this idea that maybe we can learn something earth-shattering from that piece of tape?
Well, first, I think in any capital case, you'll see multiple appeals. There's always multiple appeals. If it's juror misconduct, if it's something discovered, if it's something new, there's always appeals that come up. In this case, it's interesting because, like I said, we didn't have the same technology we had back then. And to answer your question, does water have an effect on DNA? Obviously, yes. Weather conditions always have an effect on DNA, and it can degrade it to a point where you can't test it. And back then, obviously, I think that it did degrade it to a point where it couldn't be tested, but now it can be. But to Lieutenant Gould's credit, he's absolutely right. If this comes back and it has nothing to do, it could be fish DNA. We don't know what kind of DNA it's going to bear. And if it has something that has absolutely nothing to do with the case, obviously, then they're dead in the water. If it's something else, if it is DNA from someone that was fishing in that area, if it's DNA from someone that, the decedent knew or was related to the decedent, or, something of that area, then it's going to be, I think that would be a very good cause to look at a new trial very hard and very intensely to see if that is something that would affect whether or not the jury would have come back a different way. Obviously, yes, there's a lot of other circumstantial evidence in this case. There's a lot of evidence that was pointing to him that is not this, but you can't overlook if this has something to do with the case and it's DNA that comes back that is related somehow to the decedent, then you have to look at a new trial intensely. And it could be that it's not grasping at straws. We just don't know sitting here. And the lieutenant is correct. Sitting here guessing and trying to figure out what it's going to be is very difficult until we actually see it. Now, when the DNA comes back, if it's a guy from the hardware store where this was bought, then it's not earth-shattering. If it is someone that was in the area, if it's someone that was related, if it's someone that she knew, to me, that would be a huge favor of the defense.
Yeah, great points you both are making. I want to know who's going to foot the bill for this. Who should foot the bill? Should it be Peterson's team or the state? We'll keep talking. I'm so glad you both are here. Attorney Bradford Cohen, Lieutenant Mike Gould, stand by, please. We're going to hit a break. When we come back, we got more from Scott Peterson's hearing next. It is great to have you along with us on this Friday morning. Welcome back to Court TV Live. I'm Julie Grant. So we're waiting for Alec Baldwin to return to the courthouse to continue with his involuntary manslaughter case. This will be day number 3 and perhaps the biggest day of them all, because his co-defendant, already convicted armorer Hannah Gutierrez, is set to take the stand today. And this is going to be really dicey because we know the state is calling her. The judge already ruled that she's not going to order her to testify. That was already hashed out. But the state can still subpoena her, bring her over. We think that she's going to plead the fifth. Her attorney, Jason Bowles, has given us many indications that that's what's going to happen. So why would the state want to do this? You can't get water out of a dry well, right? If she's unwilling to talk, she's unwilling to talk. Are they just trying to put her in front of the jury to get her to do that? So many questions. It could really get explosive. And to see their two reactions to each other. How are she and Baldwin going to behave when they see each other for the first time since that fatal incident back in October of 2021? They haven't seen each other in person since then. And we see Alec Baldwin arriving every day surrounded by video cameras, media from all around the world. is camped out at the courthouse in New Mexico, and that is where our Court TV team is as well. We are the pool camera, so no matter where you see the trial footage, it's our videographers who are doing the job of filming it. Right now, let's get you back to that hearing for convicted killer Scott Peterson. A key focus now for him in his bid to try to save himself. Remember, this guy, even after being convicted, sentenced to death for murdering his wife Lacey and his unborn baby Connor, he's still proclaiming his innocence. First, it was jury tampering. Now, he's saying he wants some DNA tested from a piece of duct tape found on his wife's pants. Now, remember, her body washed ashore from the bay. And this piece is about 15 inches long, and his team is saying we want it submitted to a lab. Well, who's going to pay for it? That's what I want to know. Let's listen to more of the prosecution's argument on the evidence.
The defense represented that only 2 of the 14 items they were seeking post-conviction DNA testing on had previously undergone testing. On page 132 of his motion, they indicated that the duct tape from Lacey's pants was tested in 2003 and shown to have human DNA present, but the DNA was not of an acceptable quality to generate a profile. At pages 132 to 133, the defense indicated the only other item that was previously tested was stained fabric from the back of the burned orange van. They told this court that the testing was conducted by DOJ in 2003, which indicated that there was no blood detected on the mattress cloth. As far as any prior 1405 motions, the defense told the court in its filing that additional testing was conducted by DOJ in 2019 pursuant to a 1405 stipulation, and that testing was just on that mattress cloth. The defense states at page 133, line 24, quote, "None of the remaining items of evidence have been DNA tested," end quote. The defense never informed this court of the first 1405 motion that had been filed and granted on April 19, 2013. It was after the people pointed out in our opposition that this is actually the defendant's third request and second motion for post-conviction DNA testing that the defense acknowledged in their reply. It was further pointed out that additional testing had been conducted in August through October of 2004 by defense at Forensic Science Associates. Mr. Harris, and I mean our Mr. Harris to differentiate from Pat Harris, which was the defense attorney, Mr. Harris indicated during the people's argument before this court on May 29th that the forensic testing at FSA involved several of the same items that they were seeking DNA testing for. This included, but is not limited to, the bag of debris, including the bug that they wanted tested, the target bag, several pieces of duct tape labeled item G82, cuttings from the duct tape, and a black tart. There is attached to disc 4 on the People's Opposition of our 1054.9, base page 42983, which this is the chain of custody law from Forensic Science Associates dated October 20th, 2004, sorry, didn't mean to misspeak, 2004, from Forensic Science Associates, giving the property back that I just cited, there's just 9 different items, to the DA's office and control of custody. Ms. Mitchell has acknowledged that Forensic Science Associates has conducted testing. She's limiting that testing to item 1-5. She's not disclosing the testing that had been done on all of these other items, which should have been included in the prior motion. Under the statute, once the court learns of forensic testing that has occurred in the case, then it has a duty. As this court knows, under subdivision E of Penal Code 1405, it states, quote, if the court finds evidence was subjected to DNA or other forensic testing previously by either the prosecution or the defense, it shall order the party at whose request the testing was conducted to provide all the parties and this court with access to the laboratory reports, underlying data, and laboratory notes prepared in connection with the DNA or other biological testing. Your Honor, we believe you did just that. You ordered the defense to provide us with any reports, notes, or underlying data regarding the 2004 DNA and or biological testing that had been conducted at FSA. Yet, the defense is refusing to provide those results and that information to the people.
All right, so is this guy going to get a new trial? That's the burning question. Can you imagine over 20 years it's been since Scott Peterson was convicted, and he's been lucky getting his death sentence overturned. Now we'll see if it could mean a whole new trial over the deaths of his wife, Laci, and his unborn baby, Connor. We're going to hit a break. We'll be right back next.
A-list actor Alec Baldwin is cast in the real-life role he never wanted.
I turn cup because the gun goes off.
Criminal defendant.
His lack of gun safety is something that he's going to have to answer for.
We heard that this was a toxic set.
One more.
It's not his fault. He did nothing wrong.
Is there an actor's exemption from liability when they're handling a deadly firearm?
The Alec Baldwin manslaughter trial. Live coverage today, only on Court TV.
Is that correct, Mr. Peterson? You're pleading not guilty to the 2 charges of murder plus the special denying the special allegations?
Absolutely. That's correct, Your Honor. I'm innocent.
Thank you. And the record will reflect that Mr. Peterson is present in the courtroom for a respondent, the people.
David Harris for the people.
Birgit Flatiger for the people.
All these years later, Scott Peterson still maintains his innocence despite being convicted at trial for the murder of his wife, Laci, and his unborn baby, Connor. In the next clip you're about to see from his hearing yesterday, his defense team is arguing about what they say is a lack of evidence that was presented against him.
All of Mr. Peterson's files that we have, and there are many, for any testing done by FSA, and I found none.
None of anything. Just none of anything.
Anything at all. Right. What I found, I represented in my sworn declaration, it appeared the defense reached out, asked for rates schedules, asked for, I think there was another, I'm not recalling what it was. It appeared to me from reviewing the file that they were considering doing testing, but that never happened. So just to put that issue to rest, there are no reports, there are no records of any evidence leaving MPD or DOJ other than that one record that I indicated G82. It appears that that was sent from DOJ to FSA, and that was it. I don't have any other record or report indicating that any testing was done on that. With respect to, does that satisfy the court with respect to prior testing by FSA on anything?
I'll preview. I intend to order you to file that as a declaration of the penalty of perjury, but assuming that happens, it will.
Okay, I will do so. With respect to other evidence that was provided to Siri, as part of our post-conviction investigation, as the court knows, our search is for the truth and is for any new evidence that may undermine the confidence in this conviction. So to the extent that we may have sent anything to Siri as part of our investigation, that is subject to a relationship that we have with Siri with respect to that evidence, if it even is evidence, those items, and those items only. As we stated in our statement, Siri has never, and they have pointed to no instance in which Siri has ever failed to comply with a court order to disclose test results, bench notes, etc., that Siri was doing pursuant to a court order, like the one we have here. But we may have more evidence that we are able to obtain and gather as part of our our post-conviction investigation that we want to find out whether it is evidence. It may be nothing at all. And as part of that, that's why I raised the word product argument, Your Honor. We are in the middle of searching for the truth and what happened in this case. And as part of that, I have personally interviewed, Your Honor, over 70 witnesses. We are working very, very, very hard at investigating this case because we believe it was not properly investigated the first time around 20 years ago. If we are now going to be required to disclose to the prosecution the fruits of our investigation as it's ongoing, there is no support for that. There's simply no support in the law for that.
Okay, so after hearing all the arguments, the judge said, I'm going to take all of this under advisement and then make my ruling on Monday, July 15th. So that'll be the day the court decides whether or not to grant this request by Peterson's defense team to have that piece of duct tape tested. So on Monday, that is when we're going to hear the decision and then we will report it to you. What do you think the court should do? Should this piece of duct tape be tested? Is it a smart thing to do? Let's bring in our guests, criminal defense attorney Bradford Cohen and retired lieutenant and K-9 expert, the host of Houndstown USA, Mike Gould. All right, so when we think about what the court should do in the considerations that the court should go through in deciding whether or not to grant this motion, let's kind of go through all of that and then see where we think the court should arrive in the decision. Bradford, would you start us off, please? What are some of the considerations you think the judge is going to be weighing over the weekend before she delivers her opinion?
I think she's going to look at precedents. I think she's going to imagine all the other evidence that was obtained in the case and how that other evidence was handled. Ultimately, I always feel like a court should, and courts generally do, when there's new evidence or there could be exculpatory evidence, lean towards the defense, just because, let's say there's nothing there. Well, now she has eliminated any reasonable doubt, any question that has occurred, anything that could have possibly happened. Now, if there's something there, and this DNA comes back to an individual that we can then trace down and eliminate, then she's also eliminated that. I think in my opinion, court should err on the side of caution. They should retest things that we couldn't test originally to see if there's anything there. Because I think that's what our system should be based on, is fairness. And fairness to the defense. And this is not commenting on whether my personal opinion is if he's guilty, innocent, or anything like that. What it is that we need to look at all the evidence, have every opportunity to scour that evidence, have every opportunity to see if we missed something in the past and if that would affect whether or not he gets a new trial. It could be that this is tested, there's DNA on it, and he still doesn't get a new trial. That's for down the road. But I think that in just testing this piece of evidence, I think it should be done. I think we should see what we can find out from the testing and see if that DNA is actually related to the case in any way, shape, or form.
That's a really good point, Bradford. Like you said, it's baby steps. Okay, should it be tested? That's question one. And then after we get the results, well, the bigger question is the number two that you identified, whether this means the whole thing comes back to the trial court. Appreciate all of that. Lieutenant Mike Gould, would you take us home, please, on this point? Your final thoughts. What should the court do, and what do you think the court will do?
Yeah, my final thoughts. I agree 100% with Bradford. The snow's this deep. What's another foot? It can't hurt. They excluded a lot of other more extraneous stuff, mattresses and so forth. So, of course, and I never want to sound cavalier, the importance of convicting an innocent person should be paramount in our system. So, of course, this is a DNA test. Let the chips fall where they may. The one thing I will say, as we were talking about earlier, early in my career, I worked at a maximum security state prison in New York. One thing 90% of the inmates had in common: none of them were guilty. They had access to a law library almost 24/7. And it was almost a pathological thing. I would interact with them. And Ron DeFeo, the Amityville horror murderer, he didn't think he did it. He believed in his heart he didn't do it. He thought the judge, everybody, the defense attorney, everybody, including his mother, was responsible for their deaths. So I'm always coming a little skeptical about this kind of, it's a stretch in this case.
Right. I love what you're saying, Lieutenant. I'm smiling along as you're talking. I know I've encountered a lot of those same people when I was a prosecutor. Bradford, he defends them. I know you guys both know what it's like. We saw that interview, clips of it this morning on Brian Smith, that Alaska would-be serial killer. Thank God that guy was caught. And he's still saying he's innocent. It's incredible. He's going to be sentenced today for his crimes. Big thanks to you both. Attorney Bradford Cohen, Lieutenant Mike Gold, thank you kindly for being on the show today. We'll see you soon.